It's like I don't know when this thing's popping on. Anyways, good evening, chat. Hi, guys. Tonight we got a SCOTUS double feature, and they're both cop-related things. And one of them just came out, and we listened to the oral arguments of, and that's the FBI wrong house case. And then the other one is I guess it's going to go through the police use of force, and we have the body cam or the dash cam of that use of force, and you guys will take a look at it and see what you guys think. So I think it will be interesting to take a look at and assess. So welcome everyone back to another Karen Reed free episode of the show. My name is Sean, also as potentially criminal. I'm an attorney in the Cleveland, Ohio area, and today we are going to get right into the SCOTUS stuff here. I do think it's interesting. I do think it's something we need to cover. I also will tell you as a programming note, one of my interviews, we have a special guest coming in, will be on Saturday. We're just hashing out the time now, but it's going to be Mike Crawford from the Young Jerks. He's going to come in and talk. I think it's interesting to get it from the people, and I think he's going to be a very interesting person to talk to because he's been, in the midst of this the entire time. Mike lives in Canton. So Mike actually lives on the battlefield, and being part of the press and just the entire, what's going on in town, how town's reacted, and then like the social media battlefield. Because if you guys haven't noticed, there's a lot of Twitter that's pro Karen Reed, anti Karen Reed, but there's a lot of that's like Boston centric peoples, and there have been like people running into each other and catfishing and like. It's kind of interesting. Some doxing going on. So we're going to get into all of that. And I think it's very interesting to cover. And that, when something I mentioned to Pisco with Karen Reed, it really bounced across the aisles on this one, as far as where you fell politically. So I think we're going to get to a lot of that. We're going to get to that. I think it will be good to take a look at. And yeah, Mike's a very nice guy. Also, I need to be able to tell him, I was wrong. I think, apparently the jury would buy the theory of a big murder conspiracy because they were already into it. And yeah, and I know some of you are saying, well, Sean, it was like 90 degrees outside today. Weren't you probably sweating like a pig walking around? Yeah, I was. But right now, the air is dry and chilly, and I got to put on my old guy sweater because I'm an old man. All right, chat. All right. Could I get Kate Peters on? No, but it's funny because Mike and I were talking, and I had explained to him, I know Kate Peters from before Karen Reed. So he's like, really? And I said, I'll tell you when we come on. It's very interesting. I need a catfish, Paul O'Keefe. Paul not know why they're catfish. Does Paul mean there are dogfish? Does catfish go mow, mow, mow underwater? No. Paul found out. All right. So I did piss off his audience, but how are you wearing that much clothing? Yes, I agree. The amount of textiles it does take to make clothing to cover my body. Yes, the amount of cotton it took to do this probably kept the cotton industry employed for a year. So, okay. You sweat more than a pig. Well, yes, but doing Mr. Rogers impression. I'm going to miss the Paul disses. Well, I mean, technically Turtle Boy's case's saga is still going, so it won't be all the way over. Now let's get to, we got 2 super chats here. Jefferson Post is kind of topic related. I need a rant. It's not topic related, but it's something to address. It's not a win for the toe today. Yeah, Aaron got his bond revoked and he had to post a newer bond, a heightened bond. So, yeah, Aaron didn't get sentenced today. We will cover that tomorrow on the Thursday night show. But, yeah, it wasn't a win for the toe today. And Nick got another very seldom dub. But, hey, you know what? He got his dubs. Seeing Nick use the cudgel of the state to satisfy his coke, flaccid, impotent rage boner against a guy shows how fucking broken his corrupted heart is. Hi, Sean. I mean, it is. I mean, what more do you want me to say? It's sad and pathetic. But as he stated, he's going to make everyone's going to pay. Everyone's going to pay. Okay. we're waiting with bated breath. So we'll see. We'll see about that. 2 full plantations? No, half the South. Half the South. No, it's not a streak yet, Otto. He got 1, and now he's got 2. That's 2 in a row. 3 is a streak. As Lou Brown told us, 3 makes it a winning streak, and they have happened before. They have happened before. So it is a thing out there. Let's see. Yeah, no, I cover that. You see what else you guys are saying here. So what happened to the tow? Well, Aaron's supposed to get sentenced, and Nick comes in, and there's now 2 or 3 separate victim impact statements, which I guess Kayla wrote one. The Nick wrote a fucking impact statement. Fucking crying. I mean, God Almighty. I can't wait for the transcript because I hope it gets read. I hope it's read on the record. I can't wait to fucking hear the crying in that, but we'll see. We'll see. Although I think since the sentencing fully didn't happen, we won't get access to it yet. But I mean, hopefully we hear. Hold on one second. It wasn't read today. Okay, confirming from there. AI generated Alf says Aaron should have joined the Fred and accepted the mysterious order of the Minnesota Zoo. Yeah. I can see that. Yes, the Zoominati. I mean, really, guys, it's not that. I mean, if I don't know what the allegations are, there's violations, and I'm assuming Nick will discuss what they are at some point, or they'll be discussed on the record. And if they really are violations, then there's violations. If there's not, there's not. It's just I don't generally tend to trust Nick and all the other dabblers go crying to the probation department about their veracity and their reporting. But maybe they're correct. Who knows? Maybe they're correct. Whiskey 77 says all names in blue have Nick's peen as wallpaper on their phones. I think we already knew that. I think that went without saying. You don't have to shame them like that. And then Unhung Hero with 5 subs. That's right, chat. 5 subs coming out there, crushing their way through this and showing those Grays what's up. Just like that. Look at that. Clyde is out there. Big green Clyde just boom all over those Grays. And then chat, we need to get to our one of our sponsors tonight. First of all, is the dragonstreasure.com, a haven for teen anime lovers. You know who won't be in court crying to the probation department about revenge pornography? dragonstreasure.com. The tea man won't be doing that. Buy his tea, buy his soap, buy his coffee. Promo code criminal gets you 10% off. And then, chat, we have one more. And, chat, it is Stoney's Bar and Grill. That's right, chat. Stoney's Bar and Grill at 1580 East Broadway Street in Rockville, Minnesota, chat. That's right. When push comes to shove, Cheetos doesn't tolerate retards in his bar. There's only room for one retard in his bar, and that's Aaron. So when Nick and Melton showed up, Cheeto said, "No room here. Get to stepping." And he made him step. So there you go, chat. Remember, there's only room for one retard in that bar, and it's Aaron Imholt. So, guys, take care of Stoney's. Remember, tomorrow night is $2.50 cans. It's bike night. Come out and show your support for Aaron. Crank your hog out in the middle of the road at Stoney's. So. Okay. Does the T-Man have needle tea? Don't know. I will find out. Hold on here. Let me ask him real quick. I will DM the man of tea right now. T-Man. Hold on here. Let me ask him. People would like to know if you have needle tea. You're not sure what it is, but I assume you know what they're talking about. All right, I just sent it out. We'll find out real quick, Chinny. All right. So, yeah, it's a tea with sewing needles in it. That sounds so bad. That sounds so nasty. Sounds really bad. Yeah. Is it used heroin needle tea? Oh, yeah. You brew it in a spoon. Just. All right, guys. Let's get to the cases here. Let's get to the cases we have. We have 2 cases tonight, and we'll go through the one that was decided first. This one, it's kind of sad. Kind of sad. But I think it's something we need to address and what happened. Also, real quick, chat. I know we covered it a long time ago, but I know there's been a lot of updates in the Gina Carano case. If you want to go through that too, let me know and we will. That's something you guys are interested in taking a look at because, yeah, I do think it's something we should address. But if you guys don't want to, we will not. So this is the case of Ashton Barnes through his estate because Ashton is dead. You might be like, well, oh heavens, what happened? Well, some things happened. And real quick, T-Man is saying, he says the needle tea is a tea that will pierce the heavens. It's a jasmine silver needle. So Chinny, if you're out there, Chinny, do they sell needle tea? Yes, jasmine silver needle. So go find the T-Man. Remember at the dragonstreasure.com and go get yourself some tea. Use a promo code criminal. Don't use cope. Don't use mindset. Don't do those bad ones. Don't do those bad ones. Use a quality code. Use the quality code out there, chat. It's a code for life. It's a code for life. All right. So Ashton Barnes was in Houston, Texas, and got stopped by the police. And we're gonna get to this. Here we go. Why did that not share? Okay. So here is the traffic stop. You know, the cops just cruising along. Cop is cruising along. This is back 2016, guys. If you notice here, 2016 pulls up behind him, lights him up, pulls him over, and from here we're gonna start the traffic stop as the cop. And here we go. Here's the discussion about what happens. So here we go.
Good afternoon, sir. I'm Deputy Chief of the Constable's Office. The reason you're being stopped today is because your vehicle run into a tow violation. You have your driver's license proof insurance with you? Sir? I understand that, but it has outstanding tow violation. When did you put the vehicle? About a week ago? I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it washed and turn it back in.
Okay. What's your name?
Sorry, Alicia.
Okay. You have your driver's license?
I'm watching the car.
Anything to zip on your mail down? Yes. I'm going to dig it around. I smell marijuana. There's any marijuana in the vehicle. Don't dig around. Don't dig around. Don't dig around. Okay. Do you have any identification on you? Sure, go ahead and pop the trip for me. Okay. Go ahead and put that paper off the top for me.
Guys, remember, when they tell you to step out, it's game over. Don't fight it. It's too late. You know, Pennsylvania v. Mims, they're allowed to make you get out of the car. He's all fiddling around and fucking around in the car. And that's it. There ain't nothing you can do about it. Get out of the car. Deal with it later.
Don't fucking move. Don't fucking move. Watch out, go through. Shot fire. Shot fire. Look at shot fire. Look at shot fire.
Now, there you go. He shoots Ashton twice, mortally wounds him. Ashton's able to put the car in park and then dies. Now, once again, we get to this whole nonsense of, look at the cop. You know, it's because when that guy's trying to start up a vehicle, you really want to jump into it and create an exigency where now your life is in danger. Really, because that makes total sense. So anyway, here he goes again as he does it. We'll slow it down a little bit so you guys can see it here at a little bit slower speed. And we'll mute it so it's not weird. And see, notice that it's not like he's reaching in to stop. He's like grabbing on and like mounting the car. So it's not like he leaned into the car and ended up like shooting him while he's tucked in. He's like he just mounted the car. And like that was his first instinct. So now ultimately, is Ashton an idiot for driving off? Yeah. Yeah. Just fucking stop. Like the game's over. Take your pinch like a man. Gotta take your pinch like a man. So we go from there. And we go to the case of Barnes versus Felix et al. This was argued back in January, and it was decided in May, but Kieran Reed was in full tilt already, guys, so we didn't have time to get to this. Now, the respondent is Roberto Felix. He's a law enforcement officer who pulled over Ashton Barnes for toll violations. Texas has a lot of toll roads. And that's kind of like they don't have income tax. But they have all the other taxes. Kind of like Florida. Florida's got a lot of toll roads. Why? Well, that's how they get around not having taxes. They tax you some way or another. Anyway, Barnes ordered Felix out of the car. As the car began to move forward, Felix jumped onto the door sill and fired 2 shots. Barnes was hit fatally, but managed to stop the car. About 5 seconds elapsed between the car starting, moving, and when it stopped. 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his first shot. Now, Barnes' mother, Ashton's mother, sued the cop, alleging that he violated the Fourth Amendment by using excessive force. Now, ultimately, do I think this is excessive force? No. I mean, at some point, yeah, you're toast, buddy. The cops are allowed to be retarded and use force. And he should have just take your pinch like a man. Take your pinch like a man. That's so much easier. The district court granted summary judgment to Felix, applying the Fifth Circuit's moment of threat rule, meaning he sought summary judgment and he won. The Court of Appeals, the Fifth Circuit, affirmed, applying that the moment of threat rule requires asking only whether the officer was in danger at the moment of the threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant. And they see here the precise moment of threat was the 2 seconds when Felix was clinging to the moving car. And they say because Felix could then have reasonably believed his life in danger, the shooting was lawful. Now, what does the Supreme Court say? They actually address this differently. So here's what the Supreme Court says. A claim of a law enforcement officer using excessive force during an arrest is analyzed under the Fourth Amendment and requires the force deployed to be objectively reasonable from the perspective of a reasonable officer at the scene. And notice, it's not a reasonable person, it's a reasonable police officer. And that's from Graham v. Connor. And that's a Supreme Court case. If you guys have watched John Bryan, the civil rights lawyer, he talks about this. These are critical things. If you guys do 1980, like anything with 1983 stuff or police brutality, this is where you start. You have Graham v. Connor. The inquiry into reasonableness requires analyzing the totality of the circumstances. So notice the Fifth Circuit said you only have to worry about what happens in the moment. And Supreme Court's like, no, you have to do the totality of the circumstances. And they also cite Tennessee v. Garner, which is another case that is critical to police use of force. Tennessee v. Garner was still back when the police still shot at people running away. And he shot a fleeing felon in the back. And that's the issue, was that guy actually presenting a threat of violence? So they say the analysis demands careful attention to the facts and circumstances. And they say, most notably here, the totality has no time limit. While the situation at the precise time will often matter most, earlier facts may bear on how reasonable officers would have understood and responded. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. And they say an officer's use of deadly force is justified at the moment, partly because of what had transpired preceding. The moment of threat rule conflicts with what the court's instruction is. By limiting their view to the 2 seconds before the shooting, the lower courts could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier interactions between the suspect and the officer. And there were some earlier interactions. And because of that limit, they cannot address whether the final 2 seconds would look different if set within a longer time frame. And they say a rule like that is not going to work. If you preclude the prior events, it's not reconcilable with the fact-dependent and context-sensitive approach the court has wanted. So they say they don't address a separate now, here's the thing. We do not address a question about whether or how an officer's own creation of a dangerous situation. Notice, because he jumps onto the car. It's like you see these cops every once in a while. They get in front of the car and they know the car is moving. Well, sometimes they create their own exigent circumstance. They create their own danger. They're not discussing that today. They say the courts below never confronted that issue and it was not the basis of the petition for certiorari. So, can't do it. Can't do it. But because they implied a improper and wrong assessment, it is vacated and remanded. So the summary judgment is vacated and it's remanded that they have to do the totality of the circumstances. Kagan delivered the opinion of a unanimous court. So chat, this is a 9-0. It's a 9-0. Kavanaugh filed a concurrence, which Thomas Alito and Barrett joined. So, and this isn't a super long one, you guys. This is not a super long one. Cat Scally said to look innocuous. So, who said they're 7 minutes behind? Ignore me. Yes, guys. T-Man ships everywhere, including outside the United States. So, hold on, you guys say show us Gina content when Disney gets felt, and we'll take a look at that then. All right, guys. So here's what happens. So Justice Kagan does this. Now remember, because it's a search and seizure, when the police seize you, they've stopped you and detained you and prevent you from doing anything. Well, if they're using deadly force, you're being seized. When they use force, period, it becomes a Fourth Amendment issue. You have the right to be secure in your person. So the use of deadly force violates the Fourth Amendment when it is not objectively reasonable. And that inquiry requires totality of the circumstances. So it's Tennessee v. Gardner and Graham v. Connor. And you notice, guys, you're like, wow, when did this happen? 1989, 1985. So up and through the 80s, the police could do all kinds of fucked up things to you, and courts kind of shrugged their shoulders. Police would routinely shoot at people fleeing. A lot of things used to happen back in the day that were very awful, but were deemed lawful. And they say the question here is whether the framework prevents the so-called moment of threat rule to be used. And they say under that rule, the courts only look to the circumstances. They say today we reject that approach as improperly narrowing. And they say to assess whether somebody used reasonable force, the court must consider all the relevant circumstances, including facts and events leading up to the climatic moment. So why is this important? Well, this means it goes back to the court, summary judgment goes away, and the court has to reevaluate. Now, we're not going to go through all of this. We're just going to point out that Ashton had toll violations in that car. Car was reported for doing it. Now, what happened? Well, Barnes said he did not have his license with him, and the car was a rental in his girlfriend's name. So, as he was speaking, Barnes rummaged through the car, and Felix told him several times, stop digging around. We heard that. He also commented that he smelled marijuana, which, is it bullshit? Is it true? I don't know. I'm going to presume it's probably bullshit because most of the time cops lie because that's what they do. Barnes responded that he might have some identification in the trunk, which I'm like, okay. So Felix told him to open the trunk from his seat, and Barnes did so while turning off the ignition. All that happened in less than 2 seconds. Or 2 minutes. Then things went faster. With his hand resting on his holster, Felix told Barnes to get out. Barnes opened the door but not exit. Instead, he turned the ignition back on. Felix unholstered his gun as it began to move, and the car moved forward, jumped onto the door sill. He twice shouted, "Don't fucking move," and with no visibility into the car, and is it subjectively reasonable, fired 2 quick shots. Now, I can see Barnes saying, well, I knew there was nobody else in the car. Okay, but it's a busy roadway and you're just cranking off shots. So by the time he managed to stop the car, by the time help arrived, he was dead. Oh. So Barnes' mother sued under 42 U.S.C. 1983 and alleged deprivation of rights against him through excessive force. District court granted summary judgment, and they go through all of the stuff here. They say at that moment, the court found an officer could think himself at a serious risk of harm. Well, remember, that's the wrong standard. So they show what happened here, and it wasn't correct. Now, it's interesting. The Fifth Circuit upheld it, but one of the judges, Judge Higginbotham, expressed concern with the doctrine. Even though he concurred, he's like, I kind of got a shitty feeling about this, guys. He wrote, the court can't consider the precise millisecond when an officer uses force, but everything that had transpired up till that time. And the judge says, if we had to do that, he would have found the officer's shooting was unreasonable. And I kind of think so. I think that I could see a court saying it's unreasonable at that second because he jumped on. And I think we get to the issue of police. Jeez, dry in the house today. We get to the issue of, is this a police-induced emergency? I think it is. But I think overall the courts are going to punt on something like this and say the cop was justified in doing what he did. I just think that's naturally how it's going to happen. And it's kind of one of these ones where I'm kind of like 50-50 on. Did he yell taser first? No. I mean, he blindly shot into the car. Yeah, but think about it, guys. Like, imagine if you're standing on your car. Think about it. Walk up to your car. Don't do it right now because you have to leave the area. But think about your car. If you stood on the door sill, like that part right there, and you stood on it, or even just standing next to your car when it's open, if you held a gun in your hand and it was at waist level, do you think you could probably figure out how to shoot the person sitting in the driver's seat? Probably. Probably. That wouldn't be too hard. So. Now, if the court were to say you should have just let him go, could I be like, could I accept that and think that's fine? Oh, I totally be cool with it. Yeah. So, Judge Hittenbottom. So. Now, they say we granted certiorari to address the claims and whether the courts may apply the moment of threat rule just described. We hold they may not, because it constricts the totality. And we haven't really done one of these, I think, in probably a couple years now. So this is why I really thought it was important to do. Jeez, it's awful tonight. So they say you analyze everything under the Fourth Amendment when you use excessive force is done under the Fourth Amendment through Graham. And they say the touchstone of the Fourth Amendment is reasonableness, and that's true. The reasonableness, like, how reasonable is it for you to suspect things? Developing probable cause, is it reasonable? Everything about the Fourth Amendment is reasonable. Is a warrant application reasonable? Because remember, you're still trying to say, do they have probable cause? Is it reasonable to rely on these assumptions? Is it reasonable to make these assumptions? Are these facts reasonable? Are the sources reasonable? Is everything reasonable? And it's measured in objective terms. So the question in a case like this is whether the force deployed was justified from the perspective of a reasonable officer on the scene, taking account of both the individual interest and the governmental interest at stake. And that requires you to analyze the totality of the circumstances. And there's no easy to apply legal test or on or off switch for this. And they say, rather, the Fourth Amendment requires, as we once put it, that a court slosh its way through a fact-bound morass, meaning a mess. It's like a quagmire. Like quicksand, it's a swamp. Or said more prosaically, deciding whether a use of force was objectively reasonable demands careful attention to the facts and circumstances relating to the incident as then known to the officer. And they say, for example, the severity of the crime. You could, prompting the stop can carry weight. So what was this one? Somebody hadn't paid tolls and ran through the easy pass lanes and they were getting snapped up. Okay. And they say so too can actions the officer took, such as giving warnings or trying to control the encounter. Those could all affect it. The stopped person's conduct is always relevant because it indicates the nature and level of the threat. And they say most notably here, the totality of the circumstances inquiry has no time limit. And they say, of course, the time at the shooting will be what matters most because the officer's choice in that moment is under review, but the earlier facts may bear on how it happens. Or as the federal government puts the point, those later in the moment facts cannot be hermetically sealed off from the context in which they arose. And there was a brief by the United States as amicus curiae in this one. So they were saying we want the context because if you're just addressing the heat of the moment, like in that second, that's going to be, the government's like, fuck, we'll get screwed even more. They actually like the totality of the circumstances in this. They want to keep it. And they say taking into account of the context may benefit either party in an excessive force case. Prior events may show, for example, why a reasonable officer would have perceived the threat, or instead they may show why it's innocuous. And they say the court describes what happens here. In the excessive force, in another case, they talk about here Plumhoff, concerned the fatal shooting of a driver at the end of a dangerous car chase, lasting more than 5 minutes. The driver had sped away from a traffic stop on a well-used road and tried to outrun 6 cruisers exceeding 100 miles an hour. Eventually, the fleeing car ran into one of the cruisers and came to a standstill. And they say the driver, though, still tried to escape, pumping the gas in a way that sent his wheels spinning and then putting the car in reverse. At that point, one of the officers fired several shots in the car. In a suit brought by the driver's daughters, they contended those shots were taken when the chase was already over. But this court, the Supreme Court, rejected that claim based on everything that had happened during that incident. The driver's outrageous recklessness, in the prior 5 minutes, as well as his last-second efforts to again run away. I'd say, given all of that, the court explained a reasonable officer would have concluded the driver was intent on resuming his getaway if allowed to do so, and would again pose a deadly threat to others. In short, it was justified because of what had transpired in the preceding period. So there are times where you can make this distinction. There are times where you can make that distinction. Benjamin saying, is this for criminal? This doesn't apply for civil. No, this is a civil. When you're suing the police, this is a civil lawsuit. So when we're reading this case here, Plumhoff v. Rickard, this is a guy's estate. His daughter's suing the police officer who shot him. And this one here, Barnes v. Felix, Barnes is the guy who ran away from the cops, and Felix is the cop. So this is a civil lawsuit. It's all civil. We're not talking about questions about murder. This is a civil lawsuit. These are civil standards of, obviously you can use those in a court, Graham v. Connor and Tennessee v. Gardner. When you're a police officer, you can use those in a criminal setting, but we're talking in the civil context right now about suing people. Because if you could sue them and they're liable for deprivation of rights, well, then they have to break out a checkbook. So I hope that makes sense. I hope that made sense for you. Are they differentiating compensatory versus? I'm not sure what you mean. I'm not sure what you mean there. If you want to ask again, are they differentiating compensatory versus punitive? No. This is just being able to sue the police and finding them liable for someone's wrongful death and their deprivation of rights under the color of law, the violation of their civil rights. Because really, at the end of the day, you're suing Felix, but you're suing the police department that he works for because they have the money. This guy was a constable, so you're suing the constable's office. If this was the Texas Department of Public Safety, he was a trooper, you would sue the Texas government because they're the ones who have the deep pockets. The cops generally don't. They don't have that kind of money. So, for example, if this was in Cleveland, we would sue the Cleveland Police Department or the Cuyahoga County Sheriff's Office or the Ohio Highway Patrol. Those are the people you would sue. But you have to name the officer because they're part of the lawsuit. And that's why you'd hope they'd cover it. So that's why you're going after those people. So you're not really worried about punitive and things like that at that point. You're going forward that way. And does that make sense? Is that kind of what you're looking for, Benjamin? If you're not, let me know. Did his union drop him? I don't know. I have no idea. So, I don't know. And they say the moment of threat rule prevents that sort of attention to context. It's not fair. It doesn't work. They say, recall that the district court in the Fifth Circuit limited their view to the 2 seconds before the shooting after Felix had stepped onto the door sill of the car. Those courts believed that under Fifth Circuit precedent, they could not take into account anything preceding that. And they say, so for example, they couldn't consider the reason for the stop, the earlier conduct and interactions between. And they said because of that, they could not address the final 2 seconds of the encounter if it would look different. And they say it's though the court could only consider the instant, talk about the Plumhoff case where the guy had stopped and crashed. They could only consider when the car was at a standstill, not the earlier time when it flew down the highway at 100 miles an hour. And if they had to do that where the car was wrecked and it wasn't moving, then the cop would have not been justified in using deadly force at that moment. So that's that's kind of where we're at with that. And I hope that makes sense there, because that's what we're looking at. That's what we're looking at here. And I think it's critical to understand that. Um, um, and I think it's important to know that. And I'm gonna see here. So I forgot to find this earlier. Yeah, there is and well, actually, I think we could. Is the chase available? Yes, actually, it's here. Here, I think it's here. Um, I think this is it. Hold on here. Yep, here we go. This is actually the chase. So, for example, we have. Well, we're not worried about all that. So, and you guys notice this is from 2004. These cases take a long time to weave their way through the courts, especially these 1983 cases. You're talking about over a decade. The Ashford Barnes one is nearly almost 9 years since it happened. It takes a long time. So when you're looking at this dash cam, you're like, why does it suck?
Hey, Keystone tonight, have you?
Or
Yeah, man.
this is back, like, if you guys you Zoomers out there, this is what tracking looks like. This is on a tape. This is a VHS tape. So there you go. There you go.
You ain't drinking all tonight? Where you coming from? Which hotel you coming from? Yeah, step on out for me. Step on out for me.
So there you go. He takes off.
Break, I've got one running southbound and them okay. That car I just ran, that one right there, go get it. Oh, he wrecked out, West Memphis.
And see, chat, if you heard it right there. So he went on this big chase, and these cars are ramming him. And you see this guy right here come run up to him. Look at him. This is the guy who does the shooting. They do even more.
We do have shots fired. He attempted to run over some.
They fucking hose that car down. Who, buddy? Who, buddy? They hose that car down. This Prosecutor 2000, a Terminator, maybe.
Of our officers, we do have a wreck.
Yeah, they killed the guy in the car and his passenger. So that just gets you a little bit of the taste of what we're looking at. So notice, if we were to use this standard, here that the Fifth Circuit is using, you only get to see like this much of you only get to see this much of it. You only get to see all that. And right now it doesn't look that bad. You don't get to see the high-speed chase and all the craziness. So that's, yes, West Memphis, Arkansas, Ralph's home city. That's why the court's saying we have to be able to see the whole thing. Because otherwise you just see this guy run up and they just start hosing down the car and you're like, that's not reasonable. But you have to show the rest of it, which makes it reasonable. And they're saying this part here is 100 times reasonable then. And they say, to be sure, historical facts will not often matter, as they did to the reason, as much as they did. And some of those facts may not be relevant at all. But a court deciding a use of force case cannot reveal the totality of circumstances on if they have chronological blinders. And Fenris, we can all agree, yeah, cops probably are a little too trigger happy, but it has to be done the right way. Has to be done the right way. They say that point is so evident that not even Felix quarrels with it. His defensive decisions relies on taking a different view of their meaning and question they raise. First, the agreement with what we have said. Yes, Felix acknowledges prior events are not off limits, for they may inform the perspective of a reasonable officer. And you see, this is a transcript of the oral arguments, and it's the brief for him. But now the divergence. According to Felix, the courts below acted consistently with that all times considered principle, except they only used the moment of the threat. The Fifth Circuit's moment of the threat doctrine allows for that, but the courts seem to think they can't. They say all the doctrine bars is a single kind of inquiry into whether the officer's earlier error created the need for deadly force. And they say on that issue, Felix admits the Fifth Circuit is right. An officer doesn't lose his right to defend himself just because he previously made a mistake. And now see that and they say all this doctrine bars a single kind of inquiry into whether the error itself was created. Meaning, is this a created exigency? Did the officer make it himself? But they're saying that's not relevant. You guys are saying that's not what happened in the Edgecombe case. Well, Edgecombe is different. The cops should be treated differently. No, I agree. But the court is going to say it's reasonable officer standard, not reasonable person. And they say, whatever might be said of the First Circuit law generally, the decisions below apply to rule about timing. And as shown above, both courts took pains to explain that they could only look to a 2-second snippet. And they say, because that's wrong, we got to address it. And they say, it can make no difference if the Fifth Circuit in other cases eschewed a strict time limit, because here they didn't. And they say, we are not sure if Felix correctly describes the overall state of Fifth Circuit law. And they talk about a case here that the court noted the recital of historical facts and actions of things going on prior to the shooting. And the court recognized its decisions directed an inquiry in the totality of the circumstances. They say, but then came the following. This circuit has narrowed that test. Notice they've decided we've narrowed it. They've decided they narrowed the test. So notice the Fifth Circuit has said, instead of watching the whole video, remember, chat, you get to watch just that much of it. It's all that matters. You're like, and the Supreme Court's like, no, you don't get to do that. And they say in deadly force cases, holding the inquiry there is confined to whether the officer was in danger at the moment of the threat that resulted in the shooting. And here's where we get the moment of the threat argument. And they say the problem with the statement is apparent. As we have explained, the court can't narrow it to focus on a single moment. It has to look at everything. And they say we don't address the different question Felix raises, whether how an officer's own creation factors into the reasonableness. And they're right. That's not addressed. And they say, as in another recent Fourth Amendment case, that is not before us. But that's something the court should address when eventually, when the cops make their own exigency, what happens? They say, the courts below never confronted the issue because their inquiry was so time-bound. So notice, they're even pointing out, like, you can't go back and check about the creating the dangerous situation because you didn't even get to when the dangerous situation was created. You're only looking at the moment the cop shot. And they say, in only looking at the 2 seconds before the shot, they excluded from view any actions of the officer that allegedly created the danger necessitating deadly force. They say, so to use the obvious example, the courts below did not address the relevance, if any, of Felix stepping on the door sill. And because they never considered that issue, it was not the basis of the petition for certiorari. So they're saying because they didn't assess it, we can't address it. The question was of timing alone. And they say, with that resolved, we return everything else to the courts below. It's for them to now consider the reasonableness of the shooting using the lengthier time frame we have prescribed. Accordingly, we vacate the judgment and remand for further proceedings consistent with the opinion. So it's a very basic point here, chat. the Fifth Circuit came up with its own rule, and the Supreme Court's like, no, you can't do that. Notice how ridiculous it would be, because if we're talking about for Ashton, we have to go back to when does he actually do the shooting here?
Don't fucking move. Don't fucking move.
Okay, so the shooting starts at like 2:30. So we'll just start it. We'll start it at 2. Like we'll start it here. We'll start it here. It starts at 2:28. Here we go. Otherwise, this is all you get based on the court's thing.
Fucking move. Don't fucking move.
And that's all you get to watch, chat. This is 5 minutes long. That's all you get to watch. Of those 2 minutes and 32 seconds, you get to watch just that little bit. So, David from Making Law Simple. Hi, David. Hope you're doing well, man. Kieran Reed's over. We got to do some Legos, buddy. Guys, MLS, Making Law Simple, doing the Lego streaming. I'm not sure what you're up to now, David, on your big stuff, but we need to talk, man. I need to give you a call. Hope you're doing well. Yes, congratulate Sean on his appointment to the federal bench. Oh, you mean me? Because I was going to say the Sean guy. Yeah, cool. Congrats to him. Yes, it's the best birthday present ever. But guys, David at MLS, a friend of the channel. Great guy. Great guy. So that is what the court's saying here. No, you can't do this. No, you can't do this. So that's I think it's an interesting discussion they have here. And you know, some of these kind of like the Ohio v. Ames one, guys, we covered. Some of you were like, well, that seemed kind of basic. Sometimes they are, but sometimes these are massive because an entire circuit was interpreting use of force law in the wrong way. And the court is it'll be interesting to see if we get one of these officer created emergencies happening soon. Now we got some super chats and stuff to catch up on. Whiskey 99 or Whiskey 77 for 199 says talking about all the blue names having peens. He says especially that J-Rock, that dude is super gay. Well, I'm sure he's around here. Okay, where are we? T-Rex Trucking and More for $4.99. Thank you. Says, hey, Sean, I know it's not a Kieran Reed stream and it's over, but you see that awful take from Maureen Callahan? I did. There's also another one that's really bad out there. And we'll get to some, we'll probably do some more awful take streams coming up. And my Hank Brennan video should be coming out here. It should be getting posted pretty soon. So we'll take a look at that. T-Rex Trucking More says another Dragon's Treasure code is, I'm certainly not a Fed. POSO, yes. Use the code POSO if you're not a Fed. Well, if you are a Fed, use POSO. Jefferson Post says, what can prevent getting arrested? Nothing. That's right. They aren't going to decide not to arrest you right there. You're going to have to take it. Fighting them with like that is just kind of moronic. Jefferson Post says the cop did the physical equivalent of fighting words. Yes, he did. Luke Pearson says a common theme between both cases covered today is they're solving a smaller question that's been brought up and sending it down for the lower courts to tangle with the bigger question. Yeah, because these were all dismissed at summary judgment, so the littlest thing was addressed instead of the big issues. So yes, that is very correct. It's a very correct statement, Luke. J-Rock says, what the fuck? Well, hey, it is what it is, man. Suffer. Guys, everybody in chat, tell J-Rock to suffer. Tell J-Rock to suffer. A federal bench at Denny's at this latitude? Bella says, no, it's not his fault. Don't freaking run. Take your arrest like a grown-up. Well, I think the court's, he hops on the car. He doesn't like dive in to grab the keys. He hops up onto the car sill, and it's like, why would you do that? Why would you start car surfing? That seems like you're creating the danger. So, you guys are awesome. Judges like ruling on the narrowest framework possible, except when they don't want to. When they want to do it, yes, they can be as narrow as a needle point. When they don't want to be narrow, they can be as blunt as a bowling ball. So it all depends. It all depends. So, all right, guys, moving on from here, the next thing we're going to talk about tonight is the Martin case. This is Martin v. United States. Remember, this is the case we covered where the FBI raided their house. And it wasn't even that they were like kind of close. They were completely off. They weren't even they weren't where they were supposed to be. They were not even where they were supposed to be, chat. Like, it wasn't even close. It wasn't even close. And I was going to bring it up here. The FBI never checked. This was never, ever, ever correct. It was never done properly. They never did the right things here, and they never did it. Hold on, chat. So what happened here is this is what the police were trying to do, and this is out of Hotlanta, as the kids call it. We're down in suburban Atlanta, and we're down, I don't know what this counts as, like J-Rock lives here, I guess. J-Rock, you probably live in this part of town, right? So down in South Atlanta, and they want to hit this. They want to hit a house. The FBI wants to hit a house, and they're looking for a gang hideout. So they're looking for Landau Lane. They're looking for this house on Landau Lane. Okay. And what happened from here is at this house, they were trying to find what they needed to find. No, don't. There we go. They wanted to hit this house, but instead they hit this house. Notice it's not like, oh, they meant to hit this house or this house or this house. Even then, that's still retarded as a cop. Get out and read the signs on the house. But those are a little easier to argue than this. I mean, a whole block away from each other. And it's, it's still bad. It's still bad. Are the house numbers even the same? No. This house is 3765 Denville Trace. Right here. This is 3765. And this is 3741 Landau Lane right here. Not even close. Not even close, chat. Not even close. Not even close. And when you look at these houses, I mean, they didn't look the same at street level. The FBI even acknowledges they don't look at all like where they should have been. So they raid the house on Denville. They raid the Martin's house. Throw flashbangs, kick in the door, point guns at everybody. And yeah, what happened? Well, the FBI is like, oh, we're the wrong people. We're the wrong people. Sorry. Sorry about that. So sorry. So sorry. And we're going to explain this here. So, once again, we go back to this case, and we're not going to read the syllabus here. But notice once again what happens. There's a lot of 9-0s lately out of the Supreme Court. And this one here. Gorsuch delivered the opinion for a unanimous court. Sotomayor did a concurrence, which Jackson joined. So another one, chat, a 9-0. Big fat fucking L's for the FBI. So, did they shoot the dogs? No. I don't know if they had a dog. And he says, Justice Gorsuch starts off, he says, if federal officers raid the wrong house, causing property damage and assaulting people, may the homeowners sue the government for damages? He says the answer is not as obvious as it might be, which is really wrong. It shouldn't be that hard to say, oh, hey, yeah, this actually shouldn't be allowed, because they kind of can't actually say that. That said, though, everybody agrees the Federal Tort Claims Act, the FTCA, permits some suits for wronghouse raids. But the scope of the act's permission is much less clear. And this case poses two questions, one concerning the sovereign immunity waiver and the other touching on defenses the United States may assert. Because remember, the government has sovereign immunity. The Federal Tort Claims Act is the government waiving sovereign immunity and allowing you to sue them, which is what you need in a sovereign immunity situation. And so they talk about in the pre-dawn hours of 2017, the FBI raided the wrong house, and they were looking for gang members and doing arrest warrants. Instead, they stormed a quiet family home, occupied by Curtina Martin and her son and her boyfriend. Okay, a 6-member SWAT team led by an FBI special agent, Lawrence Guerra. They breached the front door and detonated flashbangs. Fearing a home invasion, they had hid in a bedroom closet. Thank God this wasn't like, God, what's her name? God, what's her name now? What's her name? Breonna Taylor. Breonna Taylor, think about it. For some of you, if you think shit's going down, you might start cranking shots off through the wall. They say, but the SWAT team soon found the couple and dragged him out of the closet. They threw the man down and handcuffed him. Began bombarding him with questions. Meanwhile, another officer pointed the gun at Curtina Martin, who was laying on the ground. Only then did another officer stumble across some mail with the address on it and realize the team had the wrong house. They say the cause of the mistake, in preparation for the raid, he had visited the correct house to document its features and identify a staging area for the SWAT team. But he says when he used his personal GPS to navigate, it led him the wrong way. Nobody could confirm as much later because he had threw away his GPS device not long after the raid. Isn't that interesting? They destroyed cops destroying evidence, chat. No way. No way the cops threw away evidence. Wow. Wow. They say it seems the agents neither noticed the street sign for Denville Trace nor the house number, which is visible in the mailbox at the end of the driveway. Well, reading is hard for cops. Apparently, too, they failed to appreciate that a different car was parked in the driveway, one not present during his previous visit. And they say left with personal injuries and property damage with no compensation, they sued. They did so under the Federal Tort Claims Act, alleging the officers had committed negligent and intentional torts. So, they say after discovery in motion practice, the district court rejected the claims and granted summary judgment to the government. The 11th Circuit affirmed, and doing so relied on an understanding of the FTCA that no other circuit court has adopted. That's not a good sign where it's like you kind of went off the reservation. And they say to appreciate what sets it apart and how its approach affected its analysis, it helps to begin by outlining how the suit would have proceeded elsewhere. I guys, that I hope you understand. This is what the court's saying. I can't believe you fucked this up so bad, but just to show you how bad this is fucked up, we're going to tell you what should happen and why it's going to happen everywhere else. So the Federal Tort Claims Act allows those injured to sue the U.S. for damages. The statute achieves that end by waiving the government's sovereign immunity for certain tort acts committed by federal employees acting within the scope of their employment. But the statute's waiver is subject to 13 exceptions that claw back the government's immunity in certain situations. Most of these exceptions are obviously inapplicable to suits alleging police misconduct within the United States. But two in particular, the discretionary function exception and the intentional tort exception, sometimes come into play. In a suit like this one, you got to address the intentional tort exception. But located in subsection H of section 2680, it prohibits claims alleging any of 11 enumerated torts, but the exception is itself subject to a law enforcement proviso. That provision countermands the exception with respect to 6 intentional torts, including assault, battery, false imprisonment, and false arrest. They say it's against, and it's with respect to these torts against investigative or law enforcement officers. It says, so if a plaintiff alleges a federal law enforcement officer committed one or more of those 6 torts, the proviso will ensure those claims survive an encounter with the intentional tort exception. So these are the ones that survive, Chad. Those are the ones that survive. They say next, most courts turn to the discretionary function exception. And is it based on an exercise of an official's discretionary function? And they say, faced with instruction, most courts ask whether the exception precludes any of the plaintiff's remaining torts. And here the answer is often less clear-cut. The discretionary function exception forbids suits challenging decisions that involve an element of judgment or choice of a kind that the exception was designed to shield. They say, but several of our lower court colleagues report they have struggled to discern what that means. Well, it can happen. It can happen. They say, so for example, lower courts have held the exception does not shield careless or unconstitutional police conduct from scrutiny. But other courts have taken a contrary view and read the exception much more broadly. So there are times, and it all depends. Remember, guys, we got some circuit splits on this. But we don't have a circuit split on a big part of this. So they're saying the 11th Circuit, you fucked up, but there's still stuff we need to address. There's still stuff we need to address here. And they say, finally, if any of the claims survive the exception and thus fall within the waiver of sovereign immunity, courts turn to a third question. Is the government liable to the plaintiff on the merits? And when it comes to that question, the FTCA provides the government will usually be liable if a private individual, like under these circumstances, would be liable under the law of the place where the government's employee's wrongful conduct, act, or omission occurred. So, guys, this is exactly how the case should play out. The Supreme Court, if you've ever wondered, well, was the court ever just say how the law should work? They are 100% explaining how the law should work here. They say, ordinarily, the courts will find for a plaintiff they could demonstrate federal officials committed a tort under applicable state law. And yes, you're not allowed to break down someone's door. You're not allowed to flashbang people without the right to do so. You're not allowed to grab them and throw them on the ground. You're not allowed to point guns at them. You have to have a legal right to do so. So they could sue for all this stuff under Georgia law. So already, this is a great example of how this works. Now they say compare that with the 11th Circuit. Now they say this court begins as much as others do, asking whether the law enforcement proviso permits a plaintiff's intentional tort claim to advance past the exception. Okay, and that part's fine. From there, the 11th Circuit proceeds quite differently. It goes off the reservation. It says, rather than asking whether the discretionary function bars either plaintiff's tort claims is negligent or intentional tort claims, as most courts do, the 11th Circuit applies that exception only to the plaintiff's negligence claims. The 11th Circuit does so because, in its view, the law enforcement proviso does not just override the intentional torts, it also overrides all other exceptions, which is kind of ridiculous. Under that approach, any intentional tort claim covered by the proviso automatically proceeds on the merits, no matter with what any other exception has to say. They say, and to compensate, notice that means that pretty much everything automatically goes forward. And they say to compensate for that plaintiff-friendly reading, the 11th Circuit then takes a restrictive and defendant-friendly view that at the liability stage. In other courts, the FTCA will usually prevail if you could show the private individual would be liable under the law of the state where this happened. And they say the 11th Circuit, but in the 11th Circuit, the government may assert an affirmative defense under the Constitution's Supremacy Clause. And they say, and that defense defeats a claim whenever law enforcement officers' contested actions bear some nexus with furthering federal policy and can reasonably be characterized as complying with the full range of federal law. So you do have it unless basically anytime federal law enforcement are working, they're furthering federal policy. And they're complying within a full range of federal law. So, they are invincible. So what did they do? They determined that it spared the intentional tort claims for both the intentional tort and discretionary function exceptions. So those two survived. It dismissed the negligence claims under the discretionary function exception, though, because he exercised discretion in how he prepared for the warrant. So the 11th Circuit said, sorry, you don't get your negligence issue, but your intentional tort survives. But what happens? Well, for the intentional tort, the court held the government had a winning supremacy clause defense. So therefore, they got summary judgment. They say, we agree to take this case to examine the issues of the 11th Circuit. And this is namely whether this proviso overrides not just the intentional tort exception, but also the discretionary function one. And two, whether the supremacy clause affords the United States a defense. And they say, beginning with the law enforcement provision, does it countermand the intentional tort exception, as most circuits have concluded and the government argues? Or does it also provide, or does the proviso also override the other exceptions in 2680, including the discretionary function exception, as the 11th Circuit is held and the plaintiffs contend? And they say to answer that question, they turn to the law and they say, remember, it waives the federal government's immunity subject to a list of 13 exceptions that are housed in 2680. Remember, there's 13 exceptions where the government's sovereign immunity is waived. Those exceptions are lettered A through N. Your favorite letter, chat, N. Your favorite letter, chat. See, the Supreme Court was thinking about you today. The Supreme Court was thinking about you today. So, okay. Jefferson Post says, do all these 9-0s mean the lowers are FAFOing right now? Yes, they are. They're going to get slapped down and corrected. So, that is truly happening. And thank you for the super chat. And guys, thank you for the support. Like I said, this week, the week before, all throughout Karen Reed. Really all this year. You guys have been amazing. Year before, you've been amazing. Just in general, you guys are awesome people. Just want to make sure you hear that. So, with one letter is not used. And they said, rather than settling the law enforcement proviso, Congress folded it into the intentional tort exception. And they say, here's a sense of how the proviso appears in context. And they just break it down so you can understand here. And they say, the provision of this chapter shall not apply to any claim arising out of assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel, slander, misrepresentation, deceit, or interference with contract rights. Provided, meaning provided that with regard to the acts or omissions of the investigative or law enforcement officers of the United States, the provision of this chapter in section 1346 of this title shall apply to any claim arising on or after the date of the enactment out of assault, battery, false, all those things. It can arise out of it. It can arise out of it. And they say, for the purpose of the subsection, what does this mean? Are you empowered by the law to execute searches, seize evidence, or make arrests for violations of federal law? And then it says any, and then they talk about N. They have to include that any claim arising from the directives of a federal land bank, a federal intermediate credit card bank, or credit bank, or a bank for cooperatives. So, and they say this supplies an immediate clue about the scope of application. Clearly, going what's gone. You guys can figure this out. They say it appears the same subsection as the intentional tort. And they say, given that arrangement, an ordinary reader would presume the proviso modifies only subsection H. And they say, an everyday example gets this. And it says, imagine you have a shopping list and it says, please buy apples and carrots, steak. If there is a sale, bread and milk. The wife, we think, would be understandably frustrated if her husband returned home with only steak in hand because he could find nothing else discounted. Remember, he only does the sale. He gets bread and milk in addition. Otherwise, just buy apples, carrots, and a steak. And they say, reflecting that intuition about our ordinary meaning, our cases recognize absent reason to think otherwise. Statutory provisos generally modify. Hold on here, chat. I'm trying to. Where did this go? Here we go. Hold on, chat. So they say these reflect that intuition about ordinary meaning. Our cases recognize that absent to think otherwise, statutory provisos only modify the provisions which they sit. And that's true. This proviso only modifies Part H. It doesn't attach to anything else. Yes, go back out for bread and milk. So from here, nothing about this proviso gives us reason to think it works differently. They say to the contrary. One textual clue after another confirms it follows the general rule. And they say just how it's listed. This shall not apply to, followed by a list of exceptions. And they say in conjunction with the leading clause, each exception forms a standalone sentence ending with a period operating as a distinct provision. And given that, it is hard to see how this might be applied beyond subsection H. So they're saying, like, how are you this retarded? Yes, you guys are telling me about 26K. Yes, I was gonna save that for tomorrow, chat. But yes, we passed 26,000. We passed 26,000, chat. It's been a long road. It's been a hard road, but we passed 26,000. Onward. Oh, we're going all the way, chat, to 1,000,000. But we are there. We passed 26K, and I want to thank all of you for that. Yes, we did it last night. So, hold on one second. I know we did it over the weekend, I guess. 2.0 saying, but yeah, we did it, and it was a lot of fun. It was very rewarding. All right. So notice too that subsection works together to address the issue about intentional torts. And they say this exception excludes from the FTA's sovereign immunity waiver and its claims for torts like assault, battery, false imprisonment, and false arrest. So it's pretty clear. They say by contrast, it doesn't say what's going on here. So it's very clear that this is confined to the same subject matter. And I think you guys could read this and you'd say, look, I guess this stuff is you're not allowed to bring it up unless this happens out of this, and it's done there. So notice this. Part H says, yes, you do have a right to bring it up in certain situations. But it was a change. So, so they say the second sentence is telling as well. It defines the phrase investigative or law enforcement officer. In doing so, it tells us the definition applies to the subsection, but also though law enforcement officers. And they say um, it appears the exceptions for claims arising out of tax and customs collections. They say if Congress wanted to say otherwise, it might have provided a section-wide definition, but they didn't. They didn't. And they say if even more evidence was needed, comparing the statute with others would supply it. And they say often Congress creates a statutory list followed by a proviso. And they say sometimes that could suggest a proviso relates to all or the preceding subparts, not just the nearest one. But here, Congress chose a different route. They say folding it into a single exception rather than appending it to the end of the full list. And they say that suggests it only goes to Part H alone. So there's a lot of statutory construction here, chat. So they say, well, seeking to defend the 11th Circuit, the plaintiffs all we have just laid out. Remember, this is a bit of an issue here because who are the plaintiffs in this case? Well, Martin is. The Martins are. They sued. They are the plaintiffs. So you're like, well, so the court's like, are they shooting us down? Well, no. They're just limiting what they can do here because the 11th Circuit fucked this all up. So they go on to discuss what happens here. Now we move on to what occurs here. Um, and they say they address this a little bit more here. So they go on to talk about this, and it's important because you guys might say, well, this is obvious. I understand it. But this does take care of that. They say the proviso countermands that directing and instructing the waivers shall apply to certain claims. And they say because the language mirrors the language of the leading clause, the plaintiffs submit, Congress must have meant for the proviso to have the last word with each of the exceptions. And they say that does not follow. And they say, but none of that means to speak to the other exceptions. I say that doesn't make sense. And they say, but there is no limiting language. And they say Congress had no need to include limiting language in the first part of that proviso to confine it to subsection H. And notice they don't say that when you talk about subsection H here. They don't say this is limited here. They say the provisions of this chapter in section 1346B. So it applies to the entire thing. They're saying it goes to all of it. So they're pointing out how that works. So they say Congress accomplished just that by placing the proviso's first part in the same sentence as the intentional tort exception. Meanwhile, the second sentence, Congress arguably needed to confine the definition of investigative or law enforcement officer. And they say that carries a different meaning when it appears in subsection C. And they say third, they resort to legislative history. And they say they point to a committee report where Congress talked about wrong house raids, much like their own. And they argued that unless the proviso is given broad effect, it will not fulfill Congress's purpose. But they say few pieces of legislative purpose pursue any single purpose at all cost. So they say it does not, and it's not that broad. So they're still going to be able to make their arguments. But the bigger issue here becomes what the 11th Circuit did that was really retarded. And they say, can the U.S. government defeat an FDCA claim by invoking the Supremacy Clause? And they're saying, absolutely no fucking way can you do this. And showing that a Federal Officers Act had some nexus with furthering federal policy. And they say because the government now concedes that it enjoys no such defense, The court appointed Christopher Mills as an amicus. And guys, we talked about this. Remember, there was an appointed amicus who had to come in and take care of stuff. Cheeky, real quick, says, I saw Sean stuffed doll meme copiums. It was too cute. Was it real? Okay. I am working with another organization. We may have something in the works. I sent them all the pictures. We may have something coming. But as of right now, just this guy. This guy was a one-off, and he's not really the one we're looking for. But there might be a Sean plushie coming. There very well might be. We're working on it. So hang tight, Chinky. Thank you for being here, by the way. Thank you for being here. It was AI, but I still want one. Well, that's what. Well, it helps that I can give them those specs because people did, and it gives them a lot of information to pull from. So, all right. So now we move on to the issue about the problems here, and it says the amicus ably discharged responsibilities, but in the end, we find the government's concession commendable and correct. The FDCA does not permit the 11th Circuit Supremacy Clause defense. And they say the Supremacy Clause applies a rule of decision when federal and state laws conflict. That's where it comes from. That's all the Supremacy Clause does. And it provides that the Constitution shall be the supreme law of the land. The Constitution and the laws of the United States shall be the supreme law of the land. And anything in the Constitution or the laws of any state to the contrary notwithstanding. So, for example, when a regulated party cannot comply with both federal and state directives, the Supremacy Clause tells us state law must yield. That's true. And they say the FTCA is the supreme federal law addressing the liability for torts committed by its agents. It supplies the exclusive remedy for damages arising out of the official conduct. And they say, as we have seen, the government will usually be liable if a private individual would be liable. And they say, accordingly, a plaintiff may prevail in an FTCA suit by demonstrating the state in which the alleged misconduct occurred would permit a cause of action. And that would happen here. And they say because this incorporates state law in most cases, there's no conflict for the Supremacy Clause to resolve. Because they're incorporating state law. And they say, take this case. There's also no just federal tort for assault or battery. It doesn't work that way. They say Georgia law supplies the relevant law of the place where the tortious conduct occurred. And Georgia law would permit a homeowner to sue a private person for damages if that person negligently raided his house and assaulted him. They say, so the relevant federal law in this field instructs the courts to imply state law rules on who's liable. There is no discord between the two, meaning there is no conflict. They say, to be sure, it is possible, although rare, for federal and state law to conflict in an FTCA lawsuit. And it says it could happen. So, for example, in Hesse v. United States, the court held the federal maritime law, and that's where you're going to get weird things. Maritime law, rail, like anything involving railways, anything that's got a different set of rules. And chat, even though it's on a river, the Columbia River is a navigable waterway that dumps out in the Pacific in Washington State. The rules are always different. Yes, you get a whoa buddy moment. You get a whoa buddy moment. So, you need the tow discussion. There won't be tow discussion till tomorrow. We're saving it, chat. We got to save it up. So they say, though the accident occurred within the state of Oregon, it happened on navigable waters within reach of admiralty jurisdiction. They say, as a result, federal maritime law displays state tort law, just as it would in an action between private parties. They say, and that's the thing, because if you got sued in Oregon, you could then take it to federal court and say, nope, federal law covers this. And because it's maritime law, it's federal question jurisdiction. And they say in that way, the federal law will control other FTA suits where a litigant can point specifically to a constitutional text or federal statute. They say in this case, however, the 11th Circuit did not identify any federal statute or provision displacing Georgia tort law. Instead, the Court of Appeals appointed in a line of cases stemming from the court's decision. Those cases the 11th Circuit has observed held federal law. Federal officers may sometimes defeat state prosecutions by demonstrating their actions, though criminal under state law, were necessary and proper in the discharge of their federal responsibilities. In the 11th Circuit's view, that same logic works to foreclose the FTCA to suits like this. And they say, to appreciate why that view is mistaken, and notice they're trying to be very nice to the 11th Circuit. They're not saying, you're a bunch of morons. A little history helps. Henry Nagel involved an affair, a homicide, and a habeas petition. And a baldo. In 1883, Sarah Althea Hill claimed to be the wife of U.S. Senator William Sharon and sought a share of his fortune in acrimonious California divorce proceedings. Sharon admitted an affair, but insisted that Hill had forged the pair's handwritten marriage contract. Hill hired David Terry to represent her. A former Chief Justice of the California Supreme Court, Terry had resigned that post after killing another U.S. Senator in a duel. This is so, like, that's the part I love about all this shit going back in 1890. Like, this is Wild West times. This isn't like 1810, but a fucking duel. Like, how boss is that? A judge is out there just... You think he shot the guy and was like, court's adjourned. I am the law. I am the law. Do you think that's how he did it? But that is the beautiful part about some of these cases. And notice that's where they're starting off with here. Okay, well, how did that work? So they say, as the litigation wore on, lawyer and client eventually married. Ugh. Yes. That's exactly how he did it. Yes, I am the law. They say, well, no, this part's not based, Evan. This lawyer and client marrying, that gets your license revoked nowadays. You can't do that. That is bad. That won't work. You're banging your clients. How you lose your law license right away. Say eventually the dispute between Hill and Sharon wound up before the Supreme Court Justice Stephen Field while he was riding circuit. And this is back when they would actually go out and ride circuit because they weren't always in session. And they would actually get the fuck out of Washington, D.C. Terry and Justice Field were no strangers, having served together in the California Supreme Court. Even so, Justice Field issued a devastating ruling against Hill. As he announced the decision, Hill left from her seat and denounced the justice as bought and had to be carried from the courtroom. Joining the fracas, Terry punched a marshal and pulled out a Bowie knife. Imagine this. It's a judge carrying around an Arkansas toothpick. I love this. This is such an amazing case. See, we used to be cool. We used to be people of action, chat. That is your birthright. Take it. It is yours. Even after the couple spent time in jail for contempt, they continue to issue threats against Justice Field. Based. Keep doing it. Yes. We used to be a real country. He's standing there with a knife trying to stab a marshal. It's like, I thought this was America. These events found their way to the U.S. reports this way. And the U.S. reports is the reporting, like the tone, like guys, like I have the books up here, reports, or, citation law books. As Paul would say, the law building full of law books. Events found their way into U.S. reports this way. Aware of the threat Hill and Terry posed, the U.S. Attorney General ordered the Deputy Marshal, a former chief of police in Tombstone, Arizona, which he's going to be salty as fuck, to accompany Justice Field when he next rode circuit in California. That decision proved prescient, for Terry soon cornered the justice on a train and attacked him. Intervening to protect the justice, Nagel shot and killed Terry. After the guys, we're probably going to we'll read through this case on our own. This is going to be awesome. We need to read this one on our own, I think. After the shooting, California authorities arrested Nagel and began prosecuting him for murder. You guys, you know what? This is just exactly like, this is like Lon Horiuchi In Boundary County, Idaho, he was indicted for murder and manslaughter. Nagel countered by filing a petition for a writ of habeas corpus in federal court, seeking his release. When the petition reached the court, it agreed the writ should issue, reasoning the supremacy clause shielded him from state criminal charges. And that's what happened to Lon Horiuchi. After he murdered Vicky Weaver and got indicted for it, the feds removed the case to district court in Idaho, and they promptly dismissed it. And therefore, the case died. So that happens. That is how this stuff works. They say without some such protection, the court concluded, that California could frustrate federal law by prosecuting a marshal for an act which he was authorized to do so by law of the United States, an act which it was his duty to do, and in circumstances where he did no more than what was necessary and proper. When I say as memorable as will be, we don't see how it informs the task of applying the FTCA. The court's decision may stand for the proposition that federal law will preempt the state criminal law when it conflicts, and do so even in the absence of express federal legislation overriding the state law in question. But Nagel does not speak to a situation whereas here, Congress had entered the field and expressly bound the federal government to accept liability under state tort law on the same terms as a private individual. After all, no private individual could deploy this case to his advantage. It has only ever worked to shield federal officers who are discharging their duties and also discharging their pistols. So yes, Henry Nagel is only available to law enforcement, federal officials. So they say an officer, and then they say another case, an officer of the United States who had been arrested under state process for acts done while he was working for the feds. And once again, that happens if the feds kill someone and they get charged or indicted, the feds can move the case. And they say to be sure, the government may raise other defenses against tort liability, and some may be uniquely federal in nature. And they say it could be. After setting forth the general rule, the government can be held liable under state tort law in the same terms as a private individual. The section adds the government may assert any defense based upon judicial or legislative immunity, which otherwise would have been available to the employee of the United States whose act or omission gave rise to the claim, as well as any other defense to which the United States is entitled. But none of those defenses include Nagel. That decision did not recognize the judicial or legislative immunity, nor has it been understood as a defense to which the United States is entitled. Or it's not anything as a shield federal officers may assert. They say, had Congress wanted to refashion it, it might have said so. Yet it did not. So where does all that leave us? Notice that's where they're like, I love it here. I love it here. They're like, hi, you might be wondering how we got into this position now. But they say, we can say this much. The plaintiff's intentional tort claim survived the encounter with subsection H thanks to the law enforcement proviso, as the 11th Circuit recognized. But it remains for that court on remand to consider whether the discretionary function bars either the negligent or intentional tort claims. And it might. They still might lose. But at least they're having the right to sue. As we've explained, the 11th Circuit must undertake the assessment without reference to its mistaken view that it only applies to subsection A. They say, should some or all the claims survive the discretionary function, the 11th Circuit then must ask whether under Georgia law a private individual would be liable for the acts and omissions of plaintiffs allege. Notice the Supreme Court's basically saying, hey, dummies, here's your roadmap. We're going to write it out for you. Not a supremacy clause defense. Nowhere mentioned in it. And they say, having resolved that much, the plaintiffs ask us to decide more still. They call on us to determine what circumstances a discretionary function exception bar suits for wrong house rates and similar misconduct. They say, unless we take up that question, the 11th Circuit may take a too broad view of the exception and dismiss their claims again. It's probably what's going to happen. It's probably what's going to happen here, to be real, chat. We all know that. And they say, after all, in the past, the court has suggested that the function exception bars any claim unless the source of federal law prescribes a course of conduct and thus deprives the official of all discretion. They say, and that approach is mistaken. And they say, well, what are we going to do? And they say some courts don't apply the exception when law enforcement officers violate constitutional rights. Some don't. They're talking about like, how do we apply this? They say some have indicated the exception does not protect ministerial tasks. And they say the plaintiffs ask us to endorse these decisions. And they say we acknowledge that different lower courts have taken different views. We acknowledge, too, that important questions surround whether under what circumstances that exception may ever foreclose a suit like this one. But those lie well beyond the two we granted certiorari to address. And for addressing them, we would benefit from the 11th Circuit's careful re-examination of this case in the first instance. Listen to these motherfuckers. It is work enough for the day to answer these questions we took this case to resolve, and to clear away two faulty assumptions on which that court has relied in the past and redirect it to the proper inquiry. It's too hard, chat. It's hard work correcting these idiots. The judgment of the 11th Circuit is vacated and the case is remanded for further proceedings consistent with this opinion. It is so ordered. They're like, it's so hard, chat. We can't do it. It's too much work. It's work enough for the day because it's so fucking. It's just like they're Kavanaugh. Well, Kavanaugh would crack open a beer, but Sotomayor gets home and she cracks open a beer and kicks off her muddy boots, and she's just like, somebody's like, "How was your day, Sonia?" And she's like, "I'll tell you what. You have no goddamn idea what it was like today." Glug, 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 glug. Goddamn Foreman was up my ass all day long and wouldn't just let it go. Can you believe this shit? Fires up a freaking Winston as she's going. Like, seriously, listen to these people. It's so hard. It's so hard. It's so hard, chat. Oh, it's so hard. It's so hard here. So, yeah, she's like, let me hit that. So Justice Sotomayor and Jackson jump in, and they're like, we fully join. And they agree that it's wrong in two respects. They agree with that. And, they go through this, and it's just like, yeah, they all agree. And it's not fair. It's not fair. So, and they just say how they decide to tell the courts how you should apply the discretionary test. But this is probably coming back because the 11th Circuit's probably going to burn it down. So the 11th Circuit's probably going to screw the Martins over, sadly, chat. So I think that's going to happen, and we'll have to deal with it when that happens. But for right now, the 11th Circuit just got told, you guys are fucking idiots. And think about how embarrassing that is. This court is like, nah, you guys are tards. You guys are tards. Like, how does that work? Like, imagine how embarrassing that would be. Imagine how embarrassing that is. Like, you get, like, the court's like, no, you're just stupid. You're so stupid. We can't even bother to address the rest of it because we had to spend all day. They're basically, it's like your teacher, like, I spent all day rewriting your test for you. Here's your answers. Reapply them, and then we'll regrade it. And you're like, hey, Miss So-and-so, can I have another question? No, I'm done. The work is long. The day is hard for this work. It's like, Jesus Christ. Fucking. It is what it is there, chat. But remember, they won't do what they want to do. Let's see here. So MLS David, he says, I have not been that amazing. Well, thank you, David. Yes, you have been. BLT says, hey, y'all. Hello. Jefferson said, is that GPS in the dumpster of Otis Air Force Base as well? Yes. Him and Brian Higgins, they're both throwing shit in the dumpster. And, the guy's throwing shit away and looks over at Brian Higgins. Brian Higgins is like, I didn't see nothing if you didn't see nothing. And he snaps his phone and throws it away. And the FBI agent's like, I didn't see nothing if you didn't see nothing. And they both just walk away. I'm sure that's how it went. The voice of Jeebus, thank you for being here, man. Says, I was paid to sneeze. It's like The Simpsons. I was elected to lead, not to read. I was paid to sneed, not to read. Spuggood says, reading is as difficult for cops as math is for lawyers. Yes, it is. Cops are very illiterate when they don't want. They have situational illiteracy when it doesn't benefit them. May says, yes, we had 26K. And Clyde coin went to the moon. Yes. Chef Clyde chat has gone to the moon. Just look at him. Right there on the moon. Such a good boy. With Clyde coin, it's going to the moon, chat. It's going to the moon. Off their mond. And also, I just want to see, like, because apparently you guys can hear me while I was talking. Is it going to keep going here? So hold on.
Got they licking their pencils right now. Trying to write fierce as they can. Get every word of this here. Get every word of this.
No, apparently that one I'm muted. But these ones from Clyde, I'm not muted on. But anyways, guys, also thank Maddie for those two things, the Clyde going out of control and the Clyde coin on the moon. You know, such a handsome little pupper dog. Thank Maddie B for those. He put those together, and I think they're hilarious. So, ED Director says, that's exactly how the judge got his duel. I am the law. Benjamin Lewis says, I was 8 years old when I learned that an Arkansas toothpick is a 12 to 20-inch dagger type of knife. Well, it could be that, or it could be like a Bowie. You can call it an Arkansas toothpick too. But yes, yep, it's generally a long-bladed knife, which were very common in the frontier era. Lone Alaskan says, I'm a member for 10 months. Thank you, man. I appreciate that. Thank you so much for the support. Says, wishing you 26,000 happy birthdays. I appreciate that. I thank you so much for that. I was hoping you're going to say wishing you 26,000 more subs, but we'll take what we get. We'll take what we get, chat. We'll take what we get here. And real quick, hold on, chat. Let's see here. Oh, I needed to. So 1 second here, chat. I need to address this real quick. Okay. Anyways, I'll take care of that. Let's see here. Any updates on anything big? Let me see. Let me see here. Okay. So no, we're all caught up, chat. We are all caught up on everything. So we are. There we go. What else are you guys saying here? Happy Clyde Day. Yes. Well, every day is Clyde Day. Every day is Clyde Day. So, guys, I do think those are very important to address as things are concerned. They set out some big, like the Supreme Court's like really shaped a lot of stuff saying, you know, how's this stuff going to apply and how to apply these things. And it's really about these circuit courts kind of getting out of control. And remember, everybody likes to make fun of the Ninth Circuit, but these are the Fifth Circuit, which is generally based. The first case, Felix, Barnes v. Felix, the Fifth Circuit is generally based when it comes to like guns and immigration. The 11th Circuit's not too bad either. But notice these two times, these courts just went all Ricky Ritardo, and there's nothing to do about it. And let me see if I can get Clyde. Hey, Clyde! Come here, Bubba. I hear click-clacks through my headphones. Hi, Bubba. Come here. Come here. Come on. Come on. Come on. Come on. Hi. Oh, he comes right over. He comes right over. He's like, hello, fat man. He's like, hello, fat man. Can I see myself? Yep, Clyde. Here we go. We'll show you again. Because you're such a good boy, Clyde. Here you go. Look at you, Bubba. That's you. That's pretty much you, Clyde. Look at that. It's like, guys, when I turn the screen off, you're like looking at the same animal. It's like looking at the same doggo. And he still smells like the groomer. he still smells like good shampoo, not rolling around in pee or in skunk. He smells like a good boy. So, Kay says, please start over. I just got here. Benjamin says, Katanji didn't want to admit she didn't know what was going on, so she had to join because she didn't want to write a dissent. No. Char. The White House just released a Daddy's Home video. What? All right, we'll take a look at that in a second here. Made by Cheeky says, I can't find the membership button again. Oh, I'm sorry. Also, chat, something weird happened. I can't give memberships anymore. I think YouTube took it away from us. Or they're modifying things or changing stuff up. But yes, he's a good boy. Yes, he is. So when does Clyde get a Hugo Boss suit? Someday, chat. So Clyde has a new dog smell. Yes, he does. So, hi, Baba. Can you woo? Ooh, come on, Clyde. Oh, so Nate is saying Facebook's been broken, so is YouTube. So Sleaze says, I never could do it, so I think YouTube just hates me. Well, yeah, we'll see. You'll suffer. He's enjoying the scritches. Of course he does. He always enjoys the scritches. He is always enjoying them. He's just like, yeah. I think 2.0 fed him, though, because he's licking his lips, and he's like, Fatman, I need to go eat more num-nums. He's like, put me down. Put me down so I can get more treats. Oh, yeah, such a good boy. All right, Bubby, I'm going to set you down. So, Clyde is tired of shilling. Yeah, he's a hard-working dog. He's a hard-working bubber. He just gave me some licks. I don't have any food up here, Bubba. I don't have any food, man. I ate it all. Do I look like I share food? Generally, I don't. Clyde wants peens. I don't have the peens. 2.0 does. Benjamin Lewis says, Alessi's been watching me, but didn't want to admit it because of the N-word towers. Yeah, that's it. Alessi's sitting there listening to my breathtaking legal analysis, and then he walks in and he's like, you know what I'm going to do? He walks in and he sits everybody down in the trial, like in their conference room that they're borrowing. And he says, listen, guys, I've got it. I'm going to call Hank Brennan the N-word. And Alan Jackson's like, I'm not so sure that's a good idea. And David Yanetti's like, maybe you could call him a faggot instead. And Alessi's like, that's not going to have the bite that we need. And Alan Jackson's like, I don't think we should call him any of those things, even if he is them. Is the camera looking for Clyde? I don't know. Every once in a while, it's been doing it now. So KJ says Sean doesn't have a peen. You heard it, chat. Yes, you heard it. You heard it. So Lone Alaskan with 5 more subs. Thank you. Thank you so much for your support and your generosity. Thank you so much. It worked in the Rittenhouse trial. Says, shoot me, Nibba. Yeah. Do you think the foreman will come on this blog? I don't know. That would be hilarious. I think Turtle Boy's actually going to have that guy on for an interview. Or somebody was. I know he went on today or Good Morning America. And yeah, it's very interesting there. It's very interesting. Hold on here. Let me see. I think Turtle Boy, is he having him on right now? Or he's coming on at some point, I think, maybe. So I thought, I don't know for sure. Paul said, AJ, no fun. Yes. Paul said, AJ, no fun, man. And Bella says, this is why Sean doesn't get big interviews. And that's, I get it. I'm the backwater. I get it. It's okay. I am who I am. I is who I is. And Aaron eats other men's jizz. It's like Popeye the Sailor Man. I am who I am, and we is who he is. And Aaron eats another man's jizz. Toot, toot. Guys, I'd love to, and I probably never get people like that on. I don't know. I'm also only like 26,000 subs, so I'm not like Emily Baker or Peter Tragos. All that too. It is how it is. It is how it is, chat. It is how it is. And I'm sure to those guys, I sound like probably what I think Paul sounds like to me. They probably think I'm a Neanderthal. Turtle Boy and the Glare are on right now. Like, together? Oh, wow, that's kind of cool. I just rolled my mouse over that. Neat. We'll get there someday. Yeah, but here's the thing. Even if I get that big, I'm still me, and I know I'm very abrasive and very crass and all that, so it is. Okay, says gay, stop it. Well, it is what it is. I mean, at this rate, I'll have to live like 70 years to get to 100K, and I don't think even if I got skinny, that would happen. So, you will get there, maybe. One day we will, chat. We'll build a church at 100K. By God, we'll get to 100K and build ourselves a church. I promise you, chat. We will build that church at 100K. Nope, Beam Copium shows Sean wasn't near the bottom of the Karen Reed streamers. I don't think I saw. I briefly I listened to him while I was driving. I don't think I'm actually on that list he covered. So yeah, I was on the bottom. Dead Snake says, "Look, Sean, I want to watch trial coverage from any other lawyer." Well, I appreciate that. Then when I did pass away, Rep Jeff. Yeah, well, Jeff was, like I said, Jeff was one of the good ones, man. He was like the mayor of LawTube, I think, in a way. He was like the best guy. Europeans are 2.5 or 2 to 5% Neanderthal by DNA. Yeah. Did the toe get arrested today? Yes, he did. He got, basically his bond got revoked, and he had to, they imposed a higher bond on him. So he had to meet that bond, and until you meet that bond, you get arrested. So, and we'll cover this all tomorrow night, chat. We'll cover it all tomorrow night. Yes, he's the Commodore of YouTube. That's actually probably a better way of doing it. Fuzzy said, I'd take down the Pisco stream. No, because I didn't realize, to do it, I don't know how to do StreamYard through Discord, if I'm hosting. I just went on Pisco's. I was like, I'm just going over there. So, didn't really think about it. So, you have to go find it on Pisco. It'll be up. Brew braces or you pass away suddenly. Well, I mean, that can happen too. So, and if that happens, 2.0 already has a list of things she's supposed to read off. So, don't worry. Cases keep streaming a Pisco. I had a lot of fun. Jesus, you guys. Fuzzy Peach says, bug out! Oh. Quick says, Lawrex, yes. Bella gifting 5 more subs. Thank you, Bella, for your support as part of the Green Menace. Keeping chat green again. Just coming through. Just, oh, no. That's right, Grays, run. I just love watching. It's so fucking funny. It's so funny. Oh, I assumed you streamed there. I wasn't even thinking about it at that point. Tofu Brain says, why did Paula do you? Did she talk to him? I don't know if she had. What does chat get when you pass? You'll get my thanks, a million thanks, because that's how I'll feel. I'll probably cry. Speaking of Bagald, Jim Ross announced he's cancer-free this week. That is some good fucking news, chat. And also sounds like Nate the lawyer, his wife went through surgery based on what he said on Friday. And it sounds like they got what they needed to get. They, whatever they took out, they got it. And it looks like she's going to do some radiation. So that's some good fucking news. Good news out there. Guys, keep a listen to your thoughts. I know she kind of discussed it already. She got the big casino herself. She's dealing with right now. So if you guys want to help Alyssa out, buy Alyssa a coffee. I know she would appreciate it. You could also get her at Venmo at Alyssa Clips. Whatever you guys can send her way, I know she would appreciate very, very much. So you guys will all get a model. That's so funny. Oh. So, Territory says, God forbid something happens to you. Can you instruct 2.0 to one of those books on the shelf behind you? Yeah, she's got, I've got a whole thing set up for her. Oh. Brewberry says, meanwhile, my boss passed away from cancer last night. Well, I'm sorry to hear. I'm sorry to hear that. Uncivil Law Kurt saying hello. Kurt, guys, friend of the show. Great friend of the show, Kurt. Kurt, hope you're doing well, man. Hope you're adjusting to the withdrawals, the Karen Reed detox. Although it's still out there, it's lingering. But anyways, guys, Kurt did a great job of Karen Reed. Absolutely fucking crushed it. So anyways, Kurt, hope you're doing well, man. Take care. Did you watch the gym stream? 2.0 and I listened to it on the drive home. That was hilarious. And it was funny that Jim didn't know that Anna Valens was a fucking troon. And he's like, oh, it makes so much sense now. Quick says, I will not be bound by these bonds of greenitude shackled to the work of greens. Yes. Will you guys get gifts at 26K Switchies? No. You should get a 24/7 model stream. Well, on a wall says, should the Sean Stuffy have cans? Like boobs? Like man boobs? Like cans like that? Are you talking about like cans that go on like the suppressor, like on my pistol? Or are you talking about like cans of White Claw? Oh. What happened? Well, Nick and Kayla cried to the court, and the judge revoked his bond. So that's why. WMMA says, is Alyssa married? Maybe I can upgrade my insurance coverage. Oh, well, you gotta talk to her. Maybe that's something she'll be willing to do. Let's see here. You heard Alyssa might have pancreatic cancer. Yeah, that's what she's dealing with. I wish her well, but I don't have confidence. My fiance was diagnosed and gone within 3 months. Yeah, I mean, I guess it's from what Alyssa's talked about, like it's the better kind. So, fingers crossed. Say a prayer, knock on wood, throw some salt over your shoulder. Whatever it is you do, for Alyssa, she would certainly would help. Brad saying because it's all about Aaron's lawyer agreeing to it. Yeah, I mean the bigger. I mean, I'm not gonna lie, guys. When you have a protection order out there, you're generally not allowed to talk about the person. Period. So, like, if you had a protection order against me here in Ohio, and I can't contact you, but I also can't sit there on Facebook and go, Brad is a big fucking faggot, like over and over and over again, just on Facebook and blasting it out there where you can see it. That would get me called into court. Now, I would argue like that's not correct contact, but I've seen courts put people in the jail over shit like that. So that, who knows? Because we haven't seen the allegations. Right now, we have like Nick and Kayla, or I'm sorry, Nick basically tells us what the allegations are. And I don't know if they're fucking true or not. So who knows? So, yes to all of the cans. You can get the Sean Stuffy some other cans. Well, no, thank you. No, thank you. No, thank you. Oh my gosh, you guys are being yeah. Nick DeOrio plans a copy strike archivers with less than 100 subs. Well, if he does that, he's a faggot. Although a lot of the React And the React and commentary community, I mean, let's be real, chat. Most of these people are insufferable. Like, you know, if they started like, if there was a React or commentary con, and like some Al Qaeda guy walked out in the middle of it and just, you know, may there be praise to. There's only one God, and Muhammad is his only prophet. Click, and sets off a vest to like C4 and kills like half of them. We're not really losing much. I mean, it's the commentary community. So I mean, what a bitch if you're doing that. Just fucking suffer at that point. So why does everybody have cancer? Because of the sector. The sector just emits radiation. So that's why we're all getting sick. So let's see. Yeah, Aaron's back out on bond. He's back out in bail. He didn't have enough time to convert to Islam. And Dead Snake says, Inshallah, brother. Yes, Inshallah. Let's see here. I thought Muhammad never said he was the only prophet of Allah. I don't know. Do I look like I know too well? I mean, there were other prophets, but I think Muhammad's the final prophet because Jesus was technically a prophet in Islam. So yes, please be upon him. Yes. AT1 CVB41. Thank you for being here, man. I appreciate it. I think you're new. I think you're new. I think not recognizing the name of the avatar. So if you have, my apologies. Check your Discord DM. Now it's got music. Let me see here. What do we got? What do we got now? Bow, 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 bow. Ooh, Clyde Coin is I can't do that. I think that's going to be copyrighted. Thus spoke Zarathustra, I think would still be copyrighted. So I don't think it's Creative Grounds yet. So I don't know if I can do that one, Maddie. You may have to like make your own music for that or have AI music. Yes, he's the final prophet. Are you saying he's the final prophet, comma, boss? Like you're telling me, like you're like, yes, boss man show. Yes, boss. Or are you trying to say like he's the final prophet and a boss, like he's boss, or he's like a video game character boss? Yes, final and best prophet, not my words. Thank you, Marlene. Do I look like I know this? Your beard says yes. Man, when I could grow a beard in college, I could grow like an Al Qaeda beard. It was all black with a little bit of gray. So, yeah, sorry, Maddie. I don't want to. What they do there. It's a boss battle, boss. Yes. Christ is Kang. Yes, Christ is always Kang. The Desert Death Cult ain't got nothing on Christianity. Ain't got nothing on Christianity. He's the leader of Kingdom of... Yes, before there was Outer Heaven, there was the Kingdom of Heaven. He said Solid Snake to infiltrate and take out the final prophet. Yes, he gave Baldwin leprosy. Instead of fox dye, it was leprosy. Oh, yes. Oh, John DePetro had Coffin Daffer on. Oh, yeah. It's all Cope on the Karen Reed side of things. So, should you guys are saying, should Aaron get an HRO against Nick Rekieta before they get one against him? I mean, this is something, bring it up tomorrow night. We'll address it. I don't know if Aaron can get one because you're getting one against the husband, basically a family member of the victim of the crime you're currently dealing with. I'm not sure you'll be applicable to get that. The court might say, LOL, no. So I'm not sure it can happen. But that's something Aaron should talk to his attorney about. Because I have no idea. Here in Ohio, trying to get a protection order against, because we don't have harassment orders. We don't have gay stuff like that. In Ohio, the answer is turn the fucking computer off. So yeah, you wouldn't get one of those here. There'd just be a no contact order in the criminal case. Could use the hacking as the grounds for the RO? No. Nope, that won't work anywhere, really. It won't really work. Pepsi Man says, help, help, I'm being harassed, but I'm also going to keep talking about him and watching his show. Yeah, I mean, it is what it is. These protection orders and stuff are one-way streets when you're a defendant, generally. It sucks. So, one would say Nick is towing the line. Oh, yeah. Yes, Nate, Ohio is very much this way. Yes, how is cyberbullying even real? Yes. Just walk away from the screen and close your eyes. Yes. What about a protection order against Melton? You're going to go into court. You're like, Your Honor, this is some internet stuff. Okay, well, where's the guy live? He lives in Las Vegas, 1,000 miles away. That's not going to work either. That's not going to work either, chat. I mean, like, I'll just double check here. Google Maps. We're gonna Google Map this real quick. You guys are talking about this, so we'll bring it up here. Google Maps. All right. So we're gonna go to St. Cloud. I think that's the county seat for Stearns County. So we're gonna do a measure distance. We're gonna measure distance from here to Las Vegas. Look, we have to scroll a ways to get to Las Vegas. There we go. Center of Las Vegas. Downtown Las Vegas. Where the hell is this? Is this where, we'll go right here, chat. We'll go to where do you want to go here, chat? We can do, let's find the spot. You know what? We'll just pick downtown Las Vegas. We'll just go to like where it says downtown. We'll go bop. It's 1,200 miles away. It's 1,200 miles away, chat. It's 1,200 miles from where Melton lives to where Aaron lives. It's 1,200 miles away, okay? That's 1,200 miles, and then one, it's the distance between them is how many states? 1, 2, 3, 4, 5 states, the Continental Divide, and the Rocky Mountains. Yeah, I'm gonna say, what the fuck are we doing here? I think a court wouldn't grant that. You could try, can always try, but I think I would get left out of court bringing that up. But like I said, we don't have these kind of protection orders here in Ohio. We're also not gay, so as a state. Could Aaron get a protection order for his daughter? Yeah, I mean, it's probably going to be more for Aaron's ex-wife to do. She'd probably have a lot more sympathy doing it. She could probably get one. Barton Bella says, I need Ron Coleman on. Yes, I do. I love talking to Ron Coleman. He's very knowledgeable. Very knowledgeable guy, and can be very base at times. Another for $5. Another one says, will the plushie be available when? I'm hoping so. Maybe I can get it set up. I got in touch with the people at Craft Effects, and I'm hoping we can, well, track me if you're going to track me. I'm hoping we can have an answer here, maybe like soon. Maybe soon. Did I contract dysentery? Yes. That's a lot of Indians you have to fight the whole way through. Oh, it's a lot of desert out there. Yes. West of the Rockies, you're live. Yes. Wildcard line. Yes. To call from out of the United States, contact your Sprint Global number, type 1, and then dial. You guys are Art Bell fans. So, Ron Coleman advocates for unironic use of the term goy on TikTok. Really? Oh. Well, Chappie Nicer go full Himmler. Well, that is an issue. That's an issue. We need another Sean and Andrew stream. Yeah, I need to talk to him. I need to talk to Meme. I need to talk to a couple people. mean, we had Kurt on just recently, but Kurt, everybody, everybody out there. EDW Raptor says, I love how I remember the Art Bell call-in messages. Well, I remember that. Lisa Lionheart, Lex Lonehood, all of his people. And I still remember the song he would play for Dreamland, especially like when you're a kid and he's gonna be talking about like aliens and the fucking shadow people. And it's like that Dreamland thing where it's got that synthesizer part cutting through it. Man, that shit'll freak you out at like 2 a.m. when you're 12. So Ian Punnett, yes. Ian Punnett, Whitney Streamer, Linda Moulton Howe. Oh, they're all great people. So go full ass Himmler. What? Full ass Himmler sounds kind of gay. Just saying. I'm just saying that sounds a little gay. All right, guys. So I think we're all caught up here. Tomorrow night we are doing the Thursday show. Sky Queen says next trial coming up. We have a guy, Maxwell Anderson. Not related to Zach Anderson. It's a case in Milwaukee. There's also a case that somebody told me Recovery Addict showed, and it's a case here in Ohio, and it's a guy who tried to make an insanity argument when he attacked a prison guard. It's only like a day long, but I think it'll be fun to cover, like a little trial here or there. I'm sending out for it and getting some things there. So Zach Anderson did get robbed, yes. Yes, guys, our special guest, Mike Crawford from the Young Jerks, will be here on Saturday, probably a little earlier in the day. I know he likes to stream kind of in the afternoon, so I think it'll be fun. I'll be able to say, like, hey, man, chat was right. Apparently the jury believed all this time around. Like I said, there'll be a lot of mea culpas. I'll be eating a lot of shit pies. I don't think so, but it'll be a very fun time on Saturday, guys. I look forward to it. Yeah. And from there, I think we'll do some other stuff. Trying to see if I can get some other people sorted out. Karen Reed involved, and I think it's important. I think it's important. Let's see. Eat your pies. Yes, this will be a great stream. Oh, it'll be good. I'm looking forward to it. I am looking forward to it. Yes, Hell is streaming Zachariah Anderson's trial because this is the anniversary of his trial, and she's on day 5. Yes. Yes, and he did get robbed. If you guys want to see Hella over at Excited Utterance, she is covering it, guys. Go over there and give Hella, give her a thumbs up, give her a like, tell her hi. I know she would appreciate it very much. Hella's out there working really, really hard. Karam says Mike is a good people. Yeah, I disagree with his politics, certainly. Him and I, I think we would disagree on a lot, but he is a good person, yeah. And you can disagree with people and have still common ground. Sleazy says, would it be just cause for termination if I called ICE on customers at work? Maybe. Justin Time says Linda Moulton Howe is such a grifter. Yeah, but back in the day, you didn't know that. You just knew she was somebody Art Bell had on all the time. So I didn't know that was the case back. I'm like 12 years old. I didn't know she was a fucking asshole. But since I've talked to Steve Cambion, the Truth Seeker guy, he's told me all kinds of shit. And I'm like, wow, all these people were dickheads. And he's like, yes. And I'm like, that hurts that my childhood was like a lot of people Art Bell had on were assholes. And you're like, that's so mean and so sad. That is actually very sad. Oh. Did you read about the arrest of the attempted kidnappers dressing and masking as ICE agents? No, but it's not a surprise. It's not a surprise it's happening. It's a brilliant way to go prey on immigrant communities because they're never on top of just doing it, period, because they can't go to the cops. Especially whatever you do, don't talk to the cops. But you really can't in that situation. So we'll see. We will see, chat. But I think we're going to leave that here. Richard C. Hogan was a huge asshole. I've heard that too. Neurotic's been working on bringing back an Art Bell show kind of with Forbidden Frontiers. Well, that'll be interesting because he could work with like the Y files. I think that'd be kind of fun. Did I read the Barry Morphew indictment? No, I heard he got re-indicted. I have not had a chance to look at that. We may look at that over the weekend, chat. We may look at that over the weekend. So that's a good point. Ag, send me, just remind me of that because I didn't realize. I remember seeing it briefly, but yeah, we should definitely talk about that. So, and we could probably do like a Who's Barry Morphew and kind of catch everybody up on that. So, let's see. I think we're all set. I think that's it, guys. I think that's it. So chat, I'm going to leave you guys here. And in the meantime, like I said, tomorrow night, guys, we got a lot of fun stuff to talk about. I'm not going to spoil it. Obviously, Aaron's one of the things, but the rest of it, I'm not spoiling and I'm not telling you. So chat, I will see you guys tomorrow. And will we cover the Rittenhouse lawsuits? I mean, they're all bullshit. I think that like the cases have already been pending. They don't have the right causes for wrongful death. You know, in a lot of states, and I think even Wisconsin, getting acquitted is generally a defense to wrongful death or any sort of violent intentional tort because you were justified in doing it. So, but we can if there's more going on there. But chat, with that said, you guys, hope everybody has a great night tonight. See you guys tomorrow. And also keep your guys' eyes peeled. I did put out a Hank Brennan video that should be getting uploaded here any second once YouTube quits being ridiculous about it. But I will say until next time, chat, just because you did it does not mean you're guilty. Unless you're a bunch of illiterate feds and you can't read the right house number, you're guilty. And then if you're the cop who decided to jump into this, like, yeah, I kind of think you're liable too. I don't think you should have been allowed to do it, but I understand why they considered it good. But you shouldn't be allowed to do it. Well, that said, chat, you guys have a great night and take care, everybody.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?